right, we'll move to the second case on our docket. It's case number 173357.
There are plugs. I never knew. Good morning, Your Honors. If I could have a second to set up, if you don't mind. Thank you. And good morning, Your Honors. And if it pleases the court, my name is Gus Benitez, and I want to thank you all for allowing me to present oral arguments today. And I'm here representing Mr. and Mrs. Myers and Southeastern, who are the defendants in the lower case and also the counterclaimants. And Your Honor, this case presents an issue, the prevailing issue in this case, it's a parole evidence rule, and the application of the parole evidence rule before the trial court. This was a very unique case. It was a case where there were a number of, just to give you a little summary of the facts, and please stop me if I'm
I think
wasting.
we understand the facts.
Well, you've got with parole evidence judge in this case, what happened in the lower court is at the very beginning of the trial, while my client was on the stand, the judge went ahead and indicated that these are enforceable contracts, the letter agreement and the operating agreements, which we consider to be drafts. They were drafts that were signed by the Myers on July 7th, 2005, with the understanding that they were going to be kept in escrow and not released to the Hackenbergers and were not going to become binding.
Was that understanding reflected in the agreements themselves?
No, Your Honor, they were not.
Didn't the agreements say that they were the entirety of the parties' agreements, the written contract?
I believe the letter.
Other agreement?
The letter agreement had what they've claimed to be a non-reliance clause. Mm-hmm. The operating agreement it has what they claim to be a merger clause. The non-reliance clause in the operating agreement really doesn't come into play because in this case, the issue was there a breach of the oral contract to keep these documents in escrow? And the evidence was overwhelming with respect to this oral agreement, even though there was significant limitations at trial with respect to the evidence.
What was the overwhelming evidence?
Well, the overwhelming evidence is the fact you've got the parties went ahead and had two meetings, basically, that resulted in the signing of these documents. The first one was on May 5th of 2005, and the second was on July 7th, 2000.
The May 5th meeting resulted in something that was clearly marked as a draft.
Yes, Your Honor.
Nobody signed.
No, that was the first time that so-called item, the draft letter agreement for the
Nobody signed it.
Nobody signed it, but it was given to the Myers for the very first time.
Right. And then in July, they came back. They were presented with written documents, and they signed every page.
Yes, Your Honor, they did. They signed every page with the understanding that they were going to be kept in escrow and be non-binding and non-enforceable. And the
attorney for the other side, I already forgot their name, the Myers,
yes, Your Honor,
said there was no such agreement, right?
Yes, Your Honor. The Myers.
So, but let me, I'm sorry, for the other side.
Hackenberger, Your Honor.
The attorney for the Hackenberger said there was no deal like that. I didn't make that agreement. But irrespective of that, I mean, your clients perform under the agreement for 2 years, don't they?
No, they don't. Judge, absolutely not. There's no evidence of a performance of that agreement.
They walked out of that meeting with a check, didn't they?
They walked out of that agreement, and there's a stipulation before the court that that check was specifically with respect to the property and had nothing to do with the letter agreement draft.
Well, but they also got their mortgage paid off.
All right.
They got their mortgage paid off, and unlike the May 5th draft, where they were going to get $1.3 million for their property in their pocket, they were going to get money for the memorabilia. The draft that they're presented on July 5th says, no, we're not going to do that. We're not going to give you $1.3 million. We're not going to give you anything. As a matter of fact, what Hackenberger is going to put into the deal, which is $1.7 million, is no longer going to be money put in. It's going to actually be a loan, so that the Highway 46, Mike Myers, 50%, is going to owe that loan back. So the Hackenbergers basically put no money in. Whatever money they put in was going to be a loan. And the Myers instead take $5 to $6 million of memorabilia that they own in warehouses, and they take a property that's worth about $3 million, and they hand it over to the Hackenbergers and say, take this, take 50% of this, and all you got to do is promise me to loan me money in the future, which I will agree to pay you back. What reasonable human being would think that is a logical, reasonable agreement? Would that not cause pause on the Myers to say, no, we don't have a deal?
What were the terms? Your clients claimed that there was essentially an escrow agreement. We won't release these signed documents. What was the terms that they testified to of that escrow agreement? It'd be held forever? It'd be, I mean, what were the terms?
Very simple. They were going to be held there until they were corrected and until all the agreements were done and negotiated and signed and sealed. That was the deal. Their part of the deal was for the consideration on their part, which is a stipulation before the court. The party stipulated that the Myers fully complied with the oral agreement by executing the documents and leaving them with Donahue. That's a stipulation. We can't avoid that. That's what they were supposed to do. They fully performed their part of the deal. What they were supposed to do is get together. Myers, at that point in time, thought that was going to be done within 2 or 3 weeks, at the latest a month or so. What happens is that Donahue, the attorney, gets fired or leaves, whatever version you want to accept, in late August, and then the agreements are with him. It's in the same building that the Hackenbergers have their office, because he works for Hackenberger, and the agreement's left behind. All of a sudden, magically, late September, Donald Hackenberger signs the agreement. Then later on October, Glenda signs the agreement. Nobody gives signed agreements to Mr. Myers. The agreement says that only one manager was going to be there. Donald Hackenberger was going to be the manager. The operating agreements, the LLC stays with 2 managers, Michael Myers and Donald Hackenberger, and he stays that way until November of 2007, after he's thrown off the property, when Hackenberger brings back Donahue, presents the agreement and says, I declare I'm the superior being in this case. I've got absolute control, and you're out of here. I'm going to take your property that's in the warehouse to the tune of millions of dollars, and you're out. And there we are, and that's the case. And it seems like there's some hesitation with trying to understand why a businessman in Myers' position and the Hackenberger's position would have acted this way. The agreement that you say was executed, there's a contribution agreement that's supposed to identify the property that's going to go in. Not only is there not an agreement, there's not even a draft of an agreement. There's not even a legal pad with a notation, contribution agreement, let me start drafting it. They don't even draft it. There's not one exchange of motor vehicle. There's not one exchange of personal property. Nothing changes for 2 years.
You're suggesting there's plenty of reason for your client to be concerned about what's going on.
Yes, Your Honor. In hindsight,
why does he continue to buy memorabilia and put it in that warehouse?
Because all his memorabilia, not the memorabilia that's going to go into the
after
development.
July 7th, he bought memorabilia, right?
He did. I'm trying to explain, Judge, that the memorabilia he had in the warehouse is his memorabilia. It had nothing to do with the project until there was a decision, a meeting of the minds to put these properties in place.
Like the one described in the letter agreement and the operating agreement.
The contribution agreement, you mean? Yes, Your Honor. And the contribution was never drafted. And if you read past the contribution agreement, in the next line it says, these are the memorabilia or the items contained in the contribution agreement.
Why did he keep putting things in that warehouse
Judge,
if he was concerned about what was going on?
Because he thought he was the owner of all that property and he had the right to keep his property in that warehouse. There was no objection to that. Nobody said, hey, Mike, get your stuff out of here and just keep the stuff that goes into the venture. Why would a reasonable, and let's say an unreasonable, any kind of person, want to go ahead and give away $5 to $6 million and their property, their land, and everything they worked for nothing? For just the ability to have somebody tell you, if you need money and I decide to loan it to you, I'll loan it to you, but you pay it back. That is incredible to believe that somebody would have done that. And what we got a question now where the court is finding that Mallard somehow allows him, after he's given us such a difficult time in getting the evidence before the jury, invoking the parole evidence rule, which you don't invoke when you're trying to establish whether in fact there's a binding enforceable contract. We weren't trying to amend anything with a letter agreement. We weren't even there. We were at the position of saying there's a contract, there's an agreement. Yes, I understand that we had a delay because sometimes things happen. There was no expectation Donahue was going to get fired. There was no expectation they were going to sit there, two grown businessmen, and not get the work done with respect to the agreements. And then nobody expected that 2 years later, one of the grown men was going to say, I'm going to become the bully on the block, and I'm going to take this letter agreement, and I'm going to take over in charge of this development.
Why would your grown man sign something that he thought was a draft?
Because he did. I can speculate in hindsight. In this case, and the testimony is before the court, that basically he was telling Donahue, I don't want to sign the warranty deed, I don't want to exchange the property, I don't want to do anything. He forced them to do 2 notes. One of them typewritten. That means he had to go over there, dictate it to his secretary, type it up, and bring it back and give it to him.
The other one was the handwritten notations.
Handwritten notation on top of the May 5th draft.
Hey, so if the July agreements were drafts, why didn't he make Donahue write on those? Why did he pick the one from May?
Because that's what he had in his hands. These were
He didn't have the letter agreements in front of him? And he's thinking to himself, these are drafts, put the notes on the draft.
He's not a lawyer, Judge. I know that I wouldn't have done that. I know I would have walked away. You probably know that you would have walked away.
Didn't the trial judge question the credibility of his testimony in that regard?
Yes, he did. He did. As a matter of fact, that was his ruling. He said that he had the right to question his credibility. He does not have the right to question his credibility.
Didn't you raise a claim of misrepresentation or fraud in the inducement?
Yes, Your Honor.
And isn't there a credibility determination that goes with that rule?
Yes, Your Honor, but that was tried in front of the jury. The judge does not have the right to make that credibility determination, not under Mallard.
Didn't the judge make it pretty clear when he ruled that he should have done all of this before trial, but that it had been 8 years trying to get to trial, so he allowed you to introduce bits and pieces of what he later struck in order to make a determination? Because he would have preferred to have done it at a pretrial hearing. Didn't he say that when he ruled?
He said something to that effect, yes, Your Honor. He did, but it doesn't make it right. It doesn't make it right that there is evidence, Judge, there's credible, competent evidence before the record, evidence that you don't even have to rely on the Myers for. Evidence that was not, some of it was not admitted, some of it was admitted.
Well, I think I asked that question a while ago.
What's that?
What that evidence was.
And we got sidetracked, but I'd be happy to go through it, Judge. It's the testimony of Mike Myers. It's the stipulation.
Independent of the testimony.
Right, I apologize.
I'd like
I was
to
just
hear what
summarizing.
that is.
Yes, Your Honor. The stipulation of the parties, which said that Michael Myers fully performed his part of the oral agreement to keep the LA and the operating agreement drafts in escrow. We've got what happened on May 5th and what happened on May 7th. We have The fact that nothing happened for the last 2 years after the signing of the documents, we've got no contribution agreement.
Nothing happened.
Nothing happened. Nothing happened to...
The client cashed the check, the Hackenbergers paid off a mortgage, and your client continued to buy memorabilia and put it in that warehouse, right?
Yes, Your Honor.
All those things happened.
Those things happen. Those things have nothing to do with the letter agreement to regard except for the check. In the check, we've got a stipulation what it was for.
You're saying the memorabilia he bought after the July signing was just more stuff he liked that he was going to put in the warehouse to keep?
To keep, not to give to...
Then why did Hackenberger pay him for it?
Because some of it was purchased. There was some that he purchased on his own for personal use. There was some that was purchased for...
So he made a list of what was his and what was going to be Highway 46's.
I don't recall that he contemporaneously necessarily made...
Did he ever make a list?
At some point in time, he did.
From his memory?
Yes, Your Honor. And there is an inventory that's detailed with respect to the property at issue. But getting back to the...
Hackenberger did, with
Excuse me?
barcodes and everything, and pictures. Hackenberger inventoried what was in the warehouses.
Hackenberger created one inventory that my client had begun, which is talking about the list that you're referring to. There's a list that my client started. Mr. Hackenberger picked it up when when Mike Myers was thrown off the property. And there's other lists in evidence that have been identified that, Judge, I'm running out of time.
Yeah, you can reserve the remainder for rebuttal. Yeah, or you can keep going. It's 4:45
Judges,
left.
just a few seconds. I just want to emphasize that this is a case that parole evidence was not properly applicable in this case, based on the allegations and based on the issues before the court. Once we got into the trial, there was no right for the trial judge to go ahead and just strike all the evidence that was admitted. That was like pulling teeth to get that evidence in, because the parole evidence objection was sustained by the court repeatedly. And at that point, the Maller is the case that they've cited. Maller doesn't stand for the proposition. You all have decided a case, Polk versus Critton, that very clearly holds, or I shouldn't say hold, it's in the body of the agreement it says that looking and reviewing Maller requires the trier of fact to make the credibility determination. And the burden of proof is the burden of proof where you instruct somebody at the time of trial, the jury, to go ahead and follow the burden of proof or the requirements to make a finding. But there's no legal precedent for a judge to make those kind of credibility determination at that point in time. And the letter agreement doesn't, the way they treated the parole evidence rule in this case did affect the entire trial. It affected it at all levels, both the jury trial and the non-jury trial. And so I urge the court, well, I'll be back. Thank you, Your Honor.
Good morning. John Bogdanoff for the Appellees. May it please the court, this case presents a classic application of the parole evidence rule, and I think the presentation by the appellant indicates why we have the parole evidence rule. In this case, there were two documents, two agreements that were executed by the Myers on July 7, 2005. They do include a non-reliance. One includes a non-reliance. The operating agreement includes a merger clause. And the parties operated under these agreements for more than 2 years. Property was transferred by the Myers to the Highway 46 partnership. In addition, memorabilia was transferred by the Myers pursuant to this agreement. In addition, the Myers received a check for $288,000 for memorabilia that they provided pursuant to this agreement. And a mortgage, which the trial court found had come due and had been called by the bank that the Myers had on the property, was paid by the Hackenbergers so that the property would not be lost. And so all of these things happened either on July 7th or right around July 7th. And they were all pursuant to these two agreements. In addition, Mr. Myers was then appointed by Mr. Hackenberger, pursuant to the terms of the partnership agreement, to be the basically operating officer for the partnership. And he received a salary of $125,000 for 2 years to operate the business. It's only after the partners had a disagreement that for the first time, over 2 years after these agreements had been signed, that Mr. Myers announces, oh, there was a oral side agreement that we made at the time we executed the agreements, that these agreements were actually to be held in escrow, pending further, apparently pending something further. It wasn't really clear what it was. As the trial court found, the terms of this alleged oral escrow agreement were not specified by Mr. Myers in his testimony. The duration of this alleged oral agreement to put the agreements in escrow, that wasn't specified by Mr. Myers. So as the trial court found, there's a very vague, indistinct agreement that Mr. Myers was now alleging that had been entered into at the time the agreements were executed. And the trial court determined, correctly under Florida law, after hearing Mr. Myers' testimony, that this was parole evidence, that this was evidence designed to vary the terms of two unambiguous agreements that the Myers had signed on July 7, 2005. And as such, this evidence was inadmissible as parole evidence. In addition, the appellants try to allege some exceptions to the parole evidence rule. Probably the one they harp on the most is that there's an exception for issues relating to whether or not there was ever a contract agreed to. But in this case, it's obvious, it's clear. That exception doesn't apply because the case law says it doesn't apply to issues of contract performance, only contract formation. If there's a true issue as to contract formation, there may be a reason to relax the parole evidence rule. But here the parties operated under these agreements for more than 2 years. So it's clear the Myers acknowledged these agreements, which had an effective date of July 7, 2005, were in effect, and the parties were operating pursuant to them. Millions of dollars was transferred by Mr. Hackenberger on behalf of the Myers, and the Myers contributed property, memorabilia, as per these agreements. So this, at most, the issue here would relate to contract performance, and the case law we cite in the brief holds that the parole evidence rule is not relaxed in that context. In addition, they seek to raise an issue about an inducement exception to the parole evidence rule, which again, case law we cite in the brief, Sunset Point, Regions Bank, which the appellants do not respond to in their reply brief, specifically holds that inducement exception to the parole evidence rule, which admits evidence of a contemporaneous oral agreement which induces the execution of a written contract, does not apply where the oral statement directly contradicts the written agreement. In this case, that's exactly what the Myers are attempting to do. They're trying to introduce parole or oral an oral agreement that would contradict the effective date, July 7, 2005, of the two agreements that they operated under for many years. So that inducement exception doesn't even apply under the case law we cite, and they don't even respond to. Now, they go beyond that and say, well, the inducement exception does apply, and the Mallard case, which holds that there's an elevated burden of proof for the inducement exception, even though the courts recognize such exception where it's appropriate, which is not this case, but where it's appropriate, they recognize an elevated burden of proof as to admissibility of such evidence. The Mallard case, additional cases we cite in our brief, indicate this relates to the issue of admissibility of the evidence. The appellants would urge this court to hold that, well, the evidence can be admitted and then the jury can be instructed. Well, you have to find there was an elevated burden and they have to satisfy this burden. That's not what the cases say. It's an issue of admissibility. The judge makes determinations as to issues of admissibility of evidence, not the jury. So in this case, even if the fraudulent inducement exception applied, which it doesn't, even if we got to the Mallard case, as the trial court found, they didn't satisfy the Mallard case, because not only did they not meet that enhanced burden of proof, there was no proof as to the terms of any such oral agreement to hold it in escrow. And so the court did reach that point, but did say that the Mallard case, the exception recognized in the Mallard case did not apply in this case because that high standard of proof was not met, which is a condition to admissibility of the evidence. So even if we go down that path about fraudulent inducement exception, which we don't have to, but if we did, they don't even satisfy the Mallard exception, and the trial court found such. The trial court was absolutely correct in precluding introduction of the parole evidence to vary the terms of the unambiguous written agreements. The remaining issues, the standard of review is essentially on these remaining issues an issue of substantial competent evidence. These issues relate to two conversion claims. One by the appellants. They allege that Mr. Hackenberger converted certain memorabilia and personal property. The trial court found they didn't provide any proof as to identifying with specificity this property or as to the value of this property. And there's ample evidence to support that. Mr. Myers testified at one point that the memorabilia itself was worth $3.8 million. Then he stipulated at trial that the memorabilia and his personal property in dispute was worth $3.6 million. The judge said, something's not right here. Opposing counsel said, well, let's just forget that evidence. It was unfortunate. And the judge said, no, we're not going to forget it. That evidence does not support the claim of a conversion of any personal property by Mr. Hackenberger. As to the Hackenberger's conversion claim, the court found there was sufficient competent evidence to support the recovery in that instance. That related to about $54,000 that the court found that Mr. Myers had converted through the use of phony or false billing that he then had the partnership pay him for. And there's substantial competent evidence of that. There was also an issue of specific performance of the items that were agreed to be transferred that, in the letter agreement that, that the Myers had failed to transfer. These related to liquor license, some collector automobiles, and some additional memorabilia, and a trailer. The trial court found that there was sufficient evidence of that to support entry of a specific performance. The liquor license had been sold during the pendency of the litigation, so the court awarded damages in lieu of the liquor license since it was unable to specifically order transfer of the liquor license. So all of those points that were raised, substantial competent evidence, and the final judgment and the record contains substantial competent evidence to support the judge's findings in those regards. Are there any questions? Thank you very much.
With respect to those other issues, Judge, with, for instance, a specific performance, the issue is not competent, substantial evidence. The issue is whether that was raised in the pleadings, and it wasn't tried by consent. And our argument is that it was, in fact, outside the pleadings. The pleadings very clearly refer to only two requests for specific performance: the liquor license and, quote, failing and refusing to transfer Highway 46 all rights, title, and interest in those classic automobiles owned by Jano. There wasn't any request for specific performance with respect to the memorabilia. There wasn't any specific request with the trailer. There wasn't any specific request with any of the other items. And that should not be allowed based on the fact that we should be going by the pleadings. So the argument is not competent evidence. It's the fact that it went outside the pleadings. With respect to specific performance with the liquor license, there were two counts with respect to the liquor license: a breach of contract and a specific performance. With respect to the breach of contract, that was entitled to a jury trial. That was gone ahead and dismissed at the start of the case. They didn't want to pursue it. Even opposing counsel during trial indicated that the only two issues with respect to specific performance, and we cite to the record citation in our brief, are to those two items that I just referred to has nothing to do with memorabilia. Yet now what the judge is doing is transferring the entire set of memorabilia, whatever it is that's in their list, and some items that don't even exist, like for instance a CD recording. There's items there that were basically never the Myers, and in fact never existed in some respects. And those were items that were put together as a brochure back in the year 2000, just to go ahead and get new investors. They went ahead and the court indicated that there should be specific performance with respect to those too. Those were not played. Those were not part of the issues before the court. They were just decided in the final judgment that was drafted and presented to the court and signed by the court. That's way outside the pleadings. With respect to the burden of proof, and with respect to Mallard and the other evidence, including Polk versus Critton, which basically said that parole evidence, when you want to, you've got a situation like we have where the burden of proof is higher. That's for the trier of fact. It's not for the jury to decide. And the parole evidence, with respect to the parole evidence before the court, or the evidence that would indicate that there was an oral agreement between the parties, if the court would look at the May 5th draft and also the July draft, they're drastically different. That's something that we weren't allowed to get into, but it's very competent evidence with respect to indicating what was going to happen. Also, there was a July 8th letter that was submitted by the Myers to the Hackenberger that basically indicated what happened on July 8th. There's also the testimony of Mike Myers. There's the stipulation on the record. There's the two notes that were drafted by Donahue. Donahue's testimony didn't come up and say, no, we didn't do that. He basically said, no, I didn't do it, but I don't recall anything. And that's something that the trier of fact can take into consideration. Once you admitted that kind of evidence as before the record, this case should have gone to the jury at the very minimum, and the directed verdict should have been denied.
Thank you.
Thank you, Your Honor.
All right, we will take a break between this case and